Let me start by getting Tom Maher, who's going to be running everything in my absence, to introduce himself, and then we'll go through all of the other teachers, and then I'll introduce our guest.
Hey, I'm Tom Maher. I've been teaching this class here for longer than I care to remember. I do primarily criminal defense, state, federal, trials, appeals, post-conviction, and I teach, as we'll talk about later, the criminal trial practice section.
Michael?
I'm Michael Dockterman. I have been doing this for longer than I care to remember. I'm a practicing lawyer in Chicago. I come down here once a week in the spring semester to teach this class, do office hours on Monday, teach on Monday afternoon, and I try cases, mostly civil cases. The thing that we do here is civil trial practice, so a little contrast to what Tom does.
And Mark Anderson.
Yep. And I'm Mark Anderson. Actually took trial practice from Professor Beskind to show how old he is. Also a practicing lawyer, tried a lot of cases all over the country. My section will be working on civil cases because that's what I do. Have not taught in this program at Duke before, but spent a lot of time teaching lawyers in our law firm and through a program with the American College of Trial Lawyers to try to raise up the next generation of trial lawyers. Love trials and love teaching it. So looking forward to this.
And in fact, all four of these people have in common that they've taken this program, whether offered here or by an adjunct over at UNC. Natalie Hirt Adams, Natalie Adams, I have to get used to it, graduated in 2008, is that right, from law school, then went to work for a major law firm in Washington, and then clerked for a federal district judge and on the Fifth Circuit for Judge Black, if I recall, and then went to work at the U.S. Attorney's Office in Tampa. Part of her background is a degree in foreign or national security from Georgetown. So she's been doing criminal cases in that office, did for 7 years, including RICO. She got, it seems to me from the descriptions I've heard, she got the nastiest cases they had, and got to do an awful lot of trial work over those 7 years. And is now back in private practice doing white-collar defense. So Natalie's going to talk to you a little bit about it from the perspective of a recent graduate. After Tom is going to basically give you an overview of the course, and then there's going to be lots of time at the end for questions, but don't hesitate to interrupt anywhere along the way for questions. When the group is small, we can make this pretty conversational. So before Tom gets started, any questions to start? Things that you came wanting to know from the beginning. Okay, Tom?
Okay, so let's talk a little bit about what trial practice is like and what it's like here. So I thought you all might want to think about who should take trial practice, and so I did a flow chart. And as I think about it, there's kind of three groups of students: those who want to be a trial lawyer, and so there's the yeses. There's those who absolutely would be happy to get through life never stepping foot in a courtroom, and those are the no's. And then there's the maybes. So if you are a yes, the answer, should you take trial practice, is yes. You take trial practice because you get to work on trial skills. You get to do directs and crosses, use exhibits, do openings and closings, and at the end of the semester, you get to try a case. If you're a maybe, the answer is yes. You should take trial practice because it's a great way to find out if, in fact, you enjoy being in a courtroom. And you're doing it in a relatively low pressure setting. There's no client. In my cases, when I lose, clients usually go away for a very long time. And here, if you lose, nobody goes to prison or pays a large judgment. And then there's the no's, people who say, I would never, ever try a case. And I'd be happy. And should they take trial practice? And the answer, surprisingly, is yes. You should take trial practice. A lot of the skills we work on, they may be set in a courtroom, but they're ways of thinking about problems and thinking about events and then turning it into a persuasive narrative, which can be useful in just about any type of practice. So even if you are never going to try a case, there is value to coming in and taking trial practice. It is a way to learn to perform on your feet, to perform orally, to use exhibits effectively, and that can be useful in all sorts of settings. So everybody should take trial practice. That part's easy. This is a quote from one of my current students, because I teach in the fall as well. We do a non-intensive session in the fall, and I asked them, what would you tell other students? I think in some respects she came from the maybe group. She wasn't sure she wanted to do it and wanted to do this before she got into an externship or some other setting, has found out she liked it. And one of the things she says, and I think it really is true, and I'm not just saying this because she's my student, is that it is an enjoyable class. When I took this class too long ago, I always looked forward to it because there was no legal research and writing. You got to stand up and pretend to be a real lawyer and try cases, and it was just a totally different experience than any other of the other classes. And I do think the students genuinely have fun in the class. So what is trial practice? Well, I guess that's like asking what are trials. One of the things you work on and develop as a skill is the ability to kind of identify and create and present a powerful narrative. It's really storytelling. I mean, there are rules to it, and we talk about that, but ultimately you are telling your client's story. And so there's a big part of what we do in all of the sections, whether it's criminal or civil, is kind of talk about, okay, what is the story and how are you telling it? There's brainstorming. We actually, in one of the first classes, spend an hour or so just brainstorming what seems to be an incredibly simple problem, and one of the things you learn is that even a simple problem has all sorts of layers, and that it really takes time and creativity to really learn what the facts are without any regard to the law or anything of that nature, and that is an incredibly important part of actually representing clients, is learning the facts and thinking them through. You'll do witness examinations, you'll do directs, you do cross-examinations, you also play witnesses, which actually I think is a useful learning experience. I've actually had to be a witness 3 or 4 times. I will say initially it's terrifying because like, oh, I'm going to mess up. But I do think if you've been a witness, you have a better sense of what the witness is going through when you're the lawyer questioning them. So you'll be playing witnesses. You'll be using exhibits. Increasingly in my practice, and it's probably true in the civil world, exhibits have become more and more important because there's more of them. And I'll talk a little bit later on how we use some exhibits, but the cases are filled now with videos and audios, not just documents. You've got, in criminal cases, cell tower locations, you've got DNA, you've got fingerprints, and so exhibits are an incredibly important thing, and it's not just a kind of technical skill, but how do you weave it into your narrative? And then you get to practice speaking to a jury, which is really kind of the essence of storytelling. Opening statement is a chance for you to literally get up and tell your story. Closing argument is a chance you literally get up and talk about your story. Why is it true? Why does it make sense? Why does it lead to justice for your client? So you'll be doing these throughout the class. So why take it here? Well, one of the benefits is you actually have lawyers who try cases for a living. And Mr. Dockterman, do you want to explain who this is?
Does anybody know who that is?
Your childhood?
That's a Toys R Us.
Yeah, that's Jeffrey, that's right.
And did you have Jeffrey standing next to you at some point?
No, Jeffrey actually testified.
And
Jeffrey testified at the trial. He put a tie on, he testified at trial, and his testimony is in the court's opinion.
so if you get Dockterman's
You get to do those
section,
kinds of things.
He
so
represented Toys R Us. That might be a helpful starting point.
Oh, come on, take away all that.
So as Jeffrey would tell you, Michael Dockterman is an incredible litigator, incredible experience. If you want to get a sense of what kind of business litigation is about and how you litigate in that kind of setting, Dockterman's section and Mark's section are great for that. He's obviously a very skilled litigator. Then you've got Mark, who we're lucky to come in here. Mark has tried so many cases. I mean, I was blown away when I was reading this, that you had 26 trial weeks for 7 jury trials in 6 different jurisdictions during the pandemic, the 2 years preceding the pandemic. So if you want lawyers who are actually in court and not just teachers, you've got on the civil side 2 really experienced people who can share what they've learned. And then for those of you who end up with me, This is, I will say, I'm probably the only person in the room who's had a complete stranger get paid to pretend to be me. And so for those of you who don't know, there's a show called The Staircase, which is about a trial in Durham that I was involved in, and HBO, for reasons I do not understand, decided to remake it as a drama, and that's supposed to be me, and I'm supposed to be doing a cross-examination, and Colin Firth is Michael Peterson, and you can tell from the look on his face he's wishing he had a different lawyer. So I try criminal cases. For example, this week on Monday I was in court on a federal fraud case. On Tuesday I was there for a detention hearing on a gun case. It had the excitement of watching a dash cam video in which my client's car, after a high-speed chase, spun out and burst into flames. And then yesterday my client for detention actually looked like a caricature of an addict. It was amazing. So I'm in court on very different types of cases in a different setting, but I'm in court on a regular basis. So the structure of this class, which is, I think, different, I suspect, than many classes. There's 12 students per section, so we cap it so that everybody has time to perform. You will get up and perform at least once in every class. I don't think I've ever had a class in which everybody didn't get up at least once and sometimes twice. You're based primarily on what's called NETA. NETA is the National Institute of Trial Advocacy. They produce training material that real, experienced lawyers use and we use in the law school setting. They're really well done training materials. You get both live feedback immediately, and we videotape you, and then we do one-on-ones with the video. What I've been doing since the pandemic, though I've kept it up just because it works, is doing them on Zoom. So the student will share the video, we'll schedule it at whatever time works for both them and myself, and we'll spend time going through the videos, and they get to tell me what they're concerned about or what questions they have, and we get a kind of a detailed input. There are some lectures and demonstrations. Some will be live, some will be recorded. You should be aware that this is a class with an intensive weekend. And this year, for the first time, the intensive weekend begins the first day of spring semester, which is the 12th. And so if you're going to take this class, which we hope you do, you need to be here on that Thursday. You can't kind of show up partway through the weekend. That's just the nature of the schedules change at Duke. I guess we're starting a week later than we normally would.
Yeah, and late in that week, we saw it.
Yeah. And then you end with a full trial. And we do those, and I think we'll be able to do them this year before spring break. And what that means is the class is condensed, it's intensive, which I think can be great kind of as an immersive learning experience. It also means that it lasts only slightly longer than the career of a British Prime Minister, for example, and you're done. So after spring break, when you come back, you're welcome to spend as much time on your other classes when you're doing finals or things. You don't have trial practice to worry about. And then your grades are based on the trials, not that anybody cares about grades. Okay, so there is a criminal section, and that's my section. It's a little bit different. We work on trial skills just like the civil, but it's in the context of a criminal practice. So all of our problems are based on criminal cases, and that means we at least do some discussion of some of the constitutional issues, the confrontation clause, things of that nature, and a lot of discussion of kind of the strategy differences, both for a prosecutor and a criminal defendant, that you just don't have in the civil context. One of the things I've started doing is creating problems from the cases I'm actually working on, because I think it's more enjoyable. The students say they really like it. It's also somewhat more realistic in the sense that you can see how things really work. So let's see if this for example, is from a case I'm working on. That is a Glock that has a shift put in the back of it. And if you possess that and possess heroin, that's a 30-year mandatory minimum sentence consecutive to everything else you get. And then at the end, when you do the full trial, it's a criminal trial. It's a robbery gone bad, murder case. You'll either be prosecuting or defending. Fortunately, my client pled to something else other than that. We also have obviously civil section. You're going to be taking NETA problems which are civil in nature. They could be commercial disputes, they can be personal injuries, and you're getting to put that together for a final trial. So you're going to be introducing evidence and examining live witnesses in civil proceedings. You'll get to see how, if you've worked in a firm reviewing documents and haven't seen what happens in court, you now get a sense of, okay, when discovery is done and document production is done, what actually happens in court with these? You get some sense of the importance and how to use those. And then you get to learn the difference between litigating and trial work.
If I could take just a minute.
Sure.
Go back to that. So for example, the bottom exhibit there is from a case that I was actually trying while we were doing trial practice. I was trying the case in San Francisco, coming back here, we were dark on Monday, so it actually worked out reasonably well. And I would pull pieces of the case and we would use those as part of the problems that we did, so you got to see exactly what was going on. The one at the top is a case I tried last August and I just argued yesterday in the Delaware Supreme Court. And there are a couple of examples there of how you have a broken deal, and many of you will go on law firms where that's a big thing that you'll have to work on. So I thought maybe this semester we would pull a couple of examples from that case and make problems out of that, as opposed to some of the other things that we've used, so that you'll get to see exactly how it's done in real time. And I hope it becomes translatable for you in your practices when you leave the law school.
Okay, so a couple other things I think about why you may want to take trial practice. I recognize Duke actually has a great, I think, offerings of experiential learning. There's other clinics and they probably offer some of the same thing, but you get on your feet in every single class. You're going to get up and you're going to perform a cross or direct or an opening or a closing, work with exhibits. You will work generally in teams. The way it generally works is it's a two-person trial team, which is a wonderful way to litigate cases. I mean, if you're a public defender or in a small firm, that doesn't always true. Sometimes you're kind of flying solo, but this is a chance to have somebody to brainstorm with, to work together, and then go through an entire trial with. So it's very collaborative, and it's collaborative during the semester as well. And then the other thing is that you really get to kind of tap into, I think, a creative side. Okay, is there an exhibit I'd create to help tell my client's story? Is there a way I would tell their story that's not just kind of run-of-the-mill, straightforward telling the story? How am I going to cross-examine somebody? And so it's not just law, there's a real element of creativity in the class. And so, any questions? Yes?
For either criminal or civil, are there any classes we should have taken before trial practice that would be really helpful or mandatory?
For criminal, it is not important that you have taken, for example, criminal adjudication or criminal investigation. I mean, it's probably marginally helpful. It is helpful to have taken evidence, but if you haven't, from my perspective, if you're taking it at the same time, that's okay as well. And I'm certainly
there is a prereq, which is evidence, but for people who are taking it at the same time, if there is an opening, we will waive that prereq. But the first option goes to the people who have had evidence. And I think in past years, we've had a few people, at least in each section, who are taking evidence concurrently. And candidly, after a couple of weeks, it doesn't really make any difference. Because the part that we're using is fairly quickly learned.
I was going to say, I'll give you my take, is the beauty of trial practice, frankly, but the course as well, is you're really putting all this together, right? At least for me, when I was going through it, I was like, God, I wish I had been involved in trial before I even took evidence, because then you really understand how it all works. So, I mean, whatever the prerequisite is, but I think you'll if you haven't already taken it, you'll come to understand it a lot better, I think, when you get the chance to use it.
Yeah, and I routinely have a few students who are taking it at the same time, and it's never a major problem. I think by the time we're partway through the semester, it stopped being an issue. And I'm happy to talk with people about hearsay and things early in the semester if need be. Yes?
It sounds like from the structure of the class, there's a criminal and a civil component, but maybe one trial that's kind of a major trial at the end. Are you choosing
No, if you're in my section as a criminal trial, you will try the case with people in your section. So your teammate will be in your section, your opponents will be from your section.
I should say a word about the trials. They are done in a day. There are no hung juries. If the jury hangs, you don't have to try it again. They tend to last about 4 or thereabouts hours. In actual trial terms, sometimes there are breaks and things like that. And then I think most people are still doing it so that you can see your jury deliberate.
Yeah, we always do that. We now do it actually with Zoom off of somebody's computer, so the jurors are in a separate room. And I'll say that's an amazing experience because you'll never get to do that in real life. And although these are made-up cases, the jurors take them surprisingly seriously. I'll have jurors who after like 45 minutes, I'll go in there and say, no, you can stop if you want. And they're like, no, give us more time. Like, this is a made-up problem, and it's really nice outside. So, they really get into it, and you end up, I think, learning something about how your audience actually makes a decision, and that really tells you something about what's effective in trials.
And they always want to share their thoughts with you when they come back out.
Yeah. Yes?
What happens in the intensive trial weekend at the beginning of the semester, and then does that weekend conflict with winter session classes that we might have already scheduled?
There may be one day where there's overlap, that Thursday, but we're scheduling the trial practice classes start in the afternoon, so hopefully it won't be a problem. This is the first time that those two things have abutted each other. There are classes on Thursday late in the day, Friday late in the day, and then on Saturday and Sunday. The Monday is Martin Luther King holiday, which is why it's set when it is, so that there's a day off before you go back to class. And there are no regularly scheduled trial practice classes that week, so you get a week's break. And what's covered that weekend tends to be storytelling, theory of the case, direct and cross-examination, and then one other thing that I think is still yet to be determined for the spring. Sometimes it's exhibits, sometimes it's impeachment, but whatever isn't covered then will be covered in one of the following 5 weekly classes that constitute the balance of the course, and then the trials. And that's the whole course.
Yeah, and during the intensive weekend, we have the live lectures and demos, but then there'll be recorded materials for the rest of the semester that you watch whenever it works for you.
And there are readings as well. And really, this is one of those courses, we assign readings in the book, but you could read whatever you wanted to read. I mean, if there's a book you like better, it's fun.
Yeah, I was curious, is there a portion of the class where we're writing evidentiary motions and stuff like that we're submitting? Or is it just the trial?
Not really. There is a pretrial conference before the trials where, at least when I do it, you can have filed what's called a motion in limine, but this takes place in NEDA, and NEDA doesn't have any published cases or statutes. So the only authority you'll cite is the rules of evidence. And I will let people argue, but it's fairly brief. So it is really not a motions practice class, and is absolutely not a legal research and writing class.
On the civil side, we do have a final pretrial conference and a final pretrial order. And if you want to file a motion in limine, we follow Delaware law. So people typically want to file a motion in limine or two. There's no reason to entertain motions for summary judgment. But it does help crystallize thinking. And one of the other things is in a real pretrial conference, you have to confer with the other side about what you want to do and whether exhibits are going to be objected to or admitted. And as you go through, what's this exhibit going to be used for? You might want to write on that, but I wouldn't focus on that piece.
Yeah, it's not a writing course. Okay, so I want to give Natalie a chance to talk to you a little bit about her experience and answer questions from her perspective. So Natalie, if you...
Sure. Hey guys, I'm glad to be back. Professor Maher was my trial practice professor. Professor Beskind was my mock trial coach. Michael Dockterman was my very first senior partner mentor at my very first summer associate position, one all year. Mark, you and I are just going to have to figure out a way to
work together.
close the loop. Look, I think this is the best thing that you can do in law school, and I don't exaggerate when I say that. Why do you guys want to do it? Why do you guys want to take trial practice? I'm here entirely to validate your choice, so don't be afraid of saying anything. Yeah?
I think I'm in that maybe group.
Yeah?
So get exposure before I, have to pick in the real world or go down some paths.
Okay, so professional consideration. Anybody else? Yeah?
I like doing activities, rather than reading cases all day.
Literally any intensive weekend class you'll sign up for?
Yeah.
Perfect. Hey, I genuinely think this is the best thing you can do. I want to make a pitch for it in the academic context, in the professional context, and the personal context. Academically, look, great classes at Duke, world-class education. You've got sort of your three buckets of classes at Duke, right? You've got skills classes, a skills class. You've got a basic building blocks class, like procedure, evidence. And you've got substantive topics classes. Substantive topics classes are great. They're going to be great to help you pass the bar, to sort of get on your feet at law firms. But right, we all go to big law firms afterward. They're going to pay you ridiculous rates. And the reason they're going to pay you ridiculous rates is because they don't want you to litigate the basic law, right? Your topic law that you learned in your Duke class. They want you to litigate at the margin. So the actual substantive case law that you need, you're going to be learning that in the real world on your feet, right? You've got your skills courses, your legal writing. That's a great course, but every single class you have at law school is teaching you how to think like a lawyer, how to read like a lawyer, how to write like a lawyer, right? So that skill is sort of dispersed here. And frankly, when you leave Duke, you're going to go to clerkships, you're going to go to big law. That's maybe just me. I don't think you're going to get your teeth cut here in legal writing, right? You're going to go to these huge firms. You will get your drafts back. I don't care how good a writer you are. Big law has the best writers in my view. You are going to get every draft you have like bleeding red, and it's not going to feel good, but it's going to make you very, very good at writing. You're going to learn a little in your clerkship, but mostly you're going to learn it when you go to a big law firm. And then the basic skills practice, right? So procedure, evidence, things like that. I think Mark is absolutely right? You're going to learn it. You're going to learn it in your class, but you don't really get it until you put it into practice. And trial is where you really learn evidence. Trial is where you really learn procedure because you have to use it. It's like you can learn guitar and your sheet music in your room, but you're not really going to get it until get in a band, book some gigs, right? Until you use it, you're not going to get good at it, right? So trial practice will put into good use and really cement your understanding of those building blocks classes. And trial practice class is really the only place you learn trial. So for my money, right, I think it is the best bang for your buck in law school. And I genuinely think it was the best. I loved my classes at Duke. It was the best one I took. Professionally, I think, look, there are all kinds of professional currencies, right? Relationship currency, performance currency. Trial ability is a huge source of professional currency. I don't care where you go. At WilmerHale, great law firm, there were very few people there who knew how to do trials. And that meant something. If you were a trial lawyer, it meant something. It meant you were getting business. It meant you were getting put on cases. It meant you were getting everything, right? You got the fun stuff, right? United States Attorney's Office. Everyone thinks, hey, federal prosecutors try cases all the time. That is not true. Some federal prosecutors try cases all the time. A lot of federal prosecutors, and same with defense attorneys, are scared of trial, right? They are terrified of trial. It's a lot of work, and it's an art, and it's a skill. And when you go places, because there are not a lot of people who are great trial lawyers in a lot of different places, right? You don't have the same kind of mentorship that you'll have in writing at big law, right? There are going to be a ton of people at big law who are amazing writers, who have that extra gear, right? It's hard to learn the art of trial practice. There aren't a lot of people in these big firms where Duke Law students go who have tremendous trial experience. And if you don't have something to get you in that door, to get you that relationship and that mentorship, right, you're kind of figuring it out yourself. And that's true if you go to the United States Attorney's Office, if you go to the Federal Defender's Office, if you go to the state attorneys or the Public Defender's Office, right? You're kind of figuring it out yourself. So, look, professionally, there is sort of a special currency that comes with having trial experience and confidence. But there's also a real practical quality that adds to your case, right? You have better cases. Same evidence, same witnesses, same everything else. Your case is so much better if you know how to try cases, right? Because what matters in the end is knowing what evidence counts and what doesn't. And if you're good at trial, you can get a lot more stuff in. You practice, you know all the ways, you can be creative, you know the rules backwards and forwards. So you just have more evidence available to you to put in if you're good at trial, right? If you have that experience, if you have that practice. Your case starts off better. But also, even at trial, you get all your evidence in. Same evidence as the other side, let's say. Same evidence as person A, person B. If you can't do trial practice, if you can't tell the story in a way that the jury believes and in a way that the jury cares about, it doesn't matter. Earlier this year, I watched two very skilled federal prosecutors get acquittals on 33 separate counts after a multi-week long trial. They mostly got their evidence in, but the other side were better trial lawyers. They knew how to tell a story. The jury didn't care that the defendant did the crime. The jury was really invested in the defendant's story, and that was because of how the other side knew how to get certain facts in and how the other side knew how to present those facts to a jury. Straight acquittal, right? So their case was better, right? Because they knew how to try cases. And then you can get into the, what's helpful in negotiation stage, right? If I know you're scared to go to trial, am I really, do you really think you're gonna be an effective negotiator if I know, if I don't agree, we're going to trial and I'm not scared and you are, right? You lose a lot of credibility. So there is that sort of professional currency. And it's real currency too, it's not just figurative. So in February, I will try a 4-week IP case. Michael talked me into. But look, this is a case that's been going on for 8 years. There have been other counsel assigned to this client for 8 years. They are IP attorneys. They know the case backward and forward. They know the facts backward and forward. They know everything that's happened in the case backward and forward. We are replacing them. And we're replacing them because they don't know how to talk to juries. And they're amazing, they're brilliant. But the client's gonna pay us an ungodly amount of money to go to trial. In an IP software tax case, I don't know anything about software coding, literally never filed my own taxes a day in my life. Not an IP lawyer, right? But I know how to try a case. And that matters. So professionally, I think that it really does matter to know how to try cases. That's what you want to go into. If you want to, professionally be somewhere really far away from that, maybe it doesn't carry that same kind of currency. So that's why I'm going to plug it on a personal level. I think it benefits you personally. I think you are more interesting if you can try cases. You will, all of you, right, will learn, if you haven't already, that a huge part of a successful law practice is building and maintaining these social networks, right? And what you will have happen after you leave law school is you guys will all get together because you will get married. You'll start getting married. You'll go to each other's weddings. You'll keep the network intact that way, right? After that, you guys are all going to go to each other's maybe kids' birthday parties. That'll be like the next round of, hey, we all get together. After that, you'll figure out some other way to get together to maintain those networks. It'll be Christmas parties, whatever. So a bunch of lawyers are going to get together, and you will see in these parties, right, who is fun to hang out with, who is fun to talk to. And look, if you are not a trial lawyer, the stories are terrible. They suck. You walk into this one group, and they're like, man, I had this huge doc production. You would not believe the CID my client got. And it was crazy. We had like 4 documents, there was this privilege issue, and you will just listen. And then you will say that you need to refill your drink, and you will never come back. It's awful, it's awful. There aren't good stories at all. And then you'll go to like the trial lawyer crew, and they'll be like, yeah, you know, my agent cut open snow and judge, like on the witness stand. Or you'll talk about the time that you subpoenaed the woman to come to testify for you. You said, look, dressed like you're going to church, and she wears nothing on her chest but a necklace that says boss, right? And then like your agent has a conversion experience and wants to go to her church. Or you like talk about, oh yeah, you know, I mean, there are a million ridiculous trial stories. The witness who comes up and tells your agent, you know, she wants to jump off a dresser on him and bite his nose, but like in a good way, right? Only happens at trial. Trial is the worst, best time of your life. It's great. So my push here is, look, if you're on the fence, if you think, I don't know what I want to do professionally, but I think maybe trial practice would be fun. Look, I think for me, I'm 15 years out, right? I've worked in private practice. I worked in government service. I don't think there's any question. It's a no-brainer. I think it's a great class. I think you've got ridiculously good teachers, and you're just not going to have that opportunity for that intensive mentorship and training and practice with really low stakes anywhere else. So I would encourage you to do it. I hope you do it, and I don't think you could do it with anyone better.
Questions for Natalie? Yes. For Natalie. Anybody? Okay. Yeah.
Do you take the class as a 2L or a 3L, and do you think there's merit to doing either?
I'm a super nerd. I saved it like dessert. Like I did not want to take it earlier. I want to take it as a 3L. I think it would have been fine to take as a 2L, but that was my preference. I genuinely think you could take it in either year. It would benefit you, and you would be able to enjoy it and excel at it.
Other questions? Or overall questions, yeah.
How long did it take to get to try your first case after law school?
Oh man. So I went to I did 2 clerkships, so those 2 years out of the question.
I think I gave you the order wrong. She did the clerkships before she went to the midterm, right? Or,
That's right.
Yeah.
Clerk for prosecutor, right?
Exactly. And so those 2 years were out, right? I went to WilmerHale in DC, which I loved, but you don't go to trial at Big Law. So it wasn't until I left to go to the United States. Oh, sorry. Most people don't go to trial at Big Law. Present company excluded. And you certainly are very, very lucky. You won the law firm lottery if you're going as a new associate. And then I went to the United States Attorney's Office specifically to do trial. So it probably wasn't until, 2012 or 2013, so 5 years out, something.
But how long had you been at the U.S. Attorney's Office?
You can go. You can go right away. And they don't give you, they do a 2-week trial course where they send you to the NAC on the University of South Carolina. All prosecutors, baby prosecutors go. We do a mock trial course, but that is all the training you get. Like, do not go to a prosecutor or defender's office thinking you're going to get taught how to do that job. You will not. You just go for it. So having had any training, experience, thought about how you're supposed to do that, I think, incredibly beneficial. So thank you for that.
So tag on that, watching her impressive performance up here and having done that. But in Big Law you can, but some of it is having the desire to be a trial lawyer. You know, and it varies. A lot of times you don't, but I was thinking about that. I have a woman who, she was JAG Corps first, so did a little prosecuting, but then left a clerkship early. We've got, we're relatively big law, 1,200 lawyers, and 2 months after she started with us, she tried a 5-week federal case with me and gave a killer closing argument. And kind of been on that path since. She's starting a trial in Dallas next week. But it depends on a little bit of learning the skills, loving the skills, right? The advantage of this class, and I'll be quiet because I have 2 other thoughts listening to this. This class obviously is taught by people who love trial practice. And it is one of the best, I think, professionally best things you can do for a living. It is. I've been doing it for 30 whatever years and got a case coming up, picking a jury November 4th, and excited. That's a great way to earn a living, and to be able to take the class from people like that. I teach a class for our upper level litigation associates in my firm, and I was telling Don, I have a slide, the first thing I do is, whatever they taught you in trial practice in law school is wrong because those people don't try cases. So you won't fall into that category, because a lot of what people are taught is wrong. So part one is if you want to be a trial lawyer, you're really fortunate to have a class like this at your law school. Part two is I have two Duke Law students who took this class in my family. One of them's a baby trial lawyer, and she learned a ton in the class. The other is in the category that was on the far right of Tom's slide. He was an undergraduate engineer, patent prosecutor, he's now an associate, doing M&A work, like some of the biggest deals in the country at, big New York firm. He's found that he'll call me up every now and then because he's successful in M&A practice. Shockingly, a lot of deals turn into litigation, and he gets tapped to advise pre-litigation on things, and now says, it's actually pretty useful I took trial practice because I know something about, never wants to do it, never wants to be seen in a courtroom, but at least understands the game we play.
Look, maybe just to piggyback on something Mark said, do an informal survey. I challenge you, I'm almost at year 15 out. I challenge you to, if you know people who've gone to law school who are a few years out, figure out who's already burned out. And I will tell you, the percentage of trial lawyers, the percentage of people who are going to trial, who stay in law, who still like law, who are still excited, we have so much more fun. I think it's the story thing also, but I really think it's so much more fun. We don't burn out nearly at the same rate as big law or as anyone else in littler law, right? So I think that's a great point that Mark raised.
I just really quickly, is there a significant overlap between the DOJ South Carolina course and like trial practice here?
Look, I was gonna say, if you do trial practice here, you're gonna kill it at the DOJ practice course. I think you will certainly learn more here than there. Certainly more time is given here than there. And at DOJ, at the trial practice course, I love DOJ. I never thought I would be a prosecutor. In the end, I love DOJ. Don't ever, ever, ever tell me about that. But look,
My daughter's a criminal defense
and I love her
They were
dearly.
classmates.
Look, the people who are going to teach you here have so much more trial experience than the people who will teach you at the NAC. There's no question. And so it's just more sophisticated here. It's more intensive here. And that's a great brush up, or that's a great dip your feet in if you have never done it before. But there's certainly overlap, but they are, it's not in concentric circles. It's like, this one ate that one. So that's what I got.
A couple of things along those lines. One is there's an argument for, depending on your circumstances, doing your second year, which is if there is at the place you're going for your summer, at the end of your second year, a trial training program, you will shine.
Yeah.
Right? And that sort of starts you on a little bit of a trajectory if you want to do this work. And the second thing is one of the biggest things we hear back from former students is that when I went through my training, I either already knew it or I killed it or whatever, that basically they felt well equipped to do the training that they were doing to have the jobs that they were having, whether it was public interest training or whether it was private practice training, regardless of the size of the firm.
Final thing I want to say, and I recognize that many of you will go to big law, but not all of you will. There's actually occasionally Duke students who go become public defenders or other things. And I ran a nonprofit that did death penalty work for a couple of years and did hire me. And if the person we were interviewing was a great law student but hadn't shown any interest in that work during law school, they didn't get hired. So if you're going to a public defender's office or a DA's office and you say, I'd love to do trial work, and you have not taken trial practice, it sends a signal that you're actually not that serious about it and that you don't come in with that skill set. So if you've got a potential interest in going someplace and doing trials and then having not taken advantage of the opportunity to get trained in it, I think is a negative. Having taken the opportunity to gain the skills is a positive. So it's something to think about.
Other questions? Well, we thank you all for coming. We'll stay around for a little bit if anybody wants to ask anything more specific or more narrow. But we'll hope to see you in trial practice this spring, or for those of you who are 2Ls, maybe if not this year, next year. Thanks for coming.